We're live. Okay, we're back in Senate Judiciary after a fire alarm on April 23rd, still on 772. And we have Chris Donnelly here. So if you could introduce yourself and we represent floor is yours.
Great, thank you. Good morning. Chris Donnelly with the Champlain Housing Trust. I'm here also representing a series of other nonprofits around the state, Champlain nonprofits that serve the whole state. Mental housing. We collectively manage about 8,300 apartments, which is around 11-12% or so of the housing stock, rental housing stock in the state. And my organization, the Champlain Housing Trust, we serve the 3 Northwest counties, and we have about 2,000 apartments. So I don't know if we are the biggest landlord in the state, if we call that before. We are sizable. So that organization sometimes has to create some vulnerabilities. In recent years, that's meant increasing number of people that are moving out of homelessness, people with disabilities, people that are most vulnerable, very long-term folks. So people are talking about protecting folks that have disabilities or addressing our homelessness issue. That's our mission. That's what we do. In the last 5 years alone, a third of any vacancy we've had and turnover, we've served someone with homelessness. We've been asked by the state to help address the overusage of motel rooms. And we're driving our guards to try to address those issues. We're further the state that way. We're also taking on more risk that way. Our organization actually practice much of what I think a lot of the tenant advocates look at asking for. So when you have a lease with us, you have security or tenure. That means at the end of the lease, if you've been paying your rent and you are abiding by the terms of the lease, stay there as long as you want. We are on average, people are staying with us 6 years in our apartment, so people have that kind of security and stability in their lives. We also operate a form of rent stabilization. We only increase our rents to possibly through business, which means whether the property taxes going up or staffing going up, but those are also regulated because of the federal funding and state funding that we get. All of our housing is permanently affordable, which means we can't just sell it in the market. So people have stability in that too. So we're doing a lot of things that I think a lot of tenant advocates do in exchange for the public resources we receive to build the housing business. And it's our mission. In recent years, we have increased our resident service staff to support people when they hit bumps on the road, whether it's financial or health challenges. So we've been increasing the number of people in all of our organizations that reach out and try to support tenants when they need it. Our nonprofits, though, even though we operate under different rules, we're not immune to a lot of the pressures that any landlord is facing these days. And things have changed over the last 5-6 years since the pandemic, and I think increase prevalence of fentanyl and maybe more sophisticated drug operations. They're setting up shops in people's homes. And I'm using the word landlord I'm using the term landlord because I think it's important to name that. Other people may call us housing providers or what have you. I understand and agree that there's a power dynamic between landlord, property owner, and a tenant. And that's why we have laws. That's why we have these laws and books that will protect that balance. And you heard last week from somebody that these laws go after 40 years. So, and I think it's good to know the history, but I think times have changed because of the conditions have changed in our apartment. Over the past 12 weeks or so, I think I've heard read, almost every single word of testimony. It's implementable to follow the bill. And then I also heard Pro Tem yesterday talk about how there's only limited time left in the session to do big things. And I've been around this building for 20 years. I've seen some big things happen, and I understand that I was here when the housing bond was passed. About 10 years ago, so last year when you guys did the infrastructure chip bill, I've seen some big things happen that have succeeded. I've seen some big things that proposed that failed. Think of a 10-year housing plan. Number one, I wouldn't call this a big deal. I'd call this a medium big deal. And I also think that there's a way to make it appropriately sized if you have context to make something that's meaningful. And I want to with openness find that program. Number one priority for the nonprofit housing groups is that when there's something violent happening in our properties, whether it's drug dealing or other criminal activity, that we need to have ask questions. Heard plenty of the horror story, I'm sure. I don't know if she's need to do social right now. I know one of our board members sent you all a note about her experience with living next to or in the same building with a person who was housing habit for 2 years. So but the vulnerable tenants are at risk. We just need to find ways to do it faster because that's our job. We have also seen an increase in our rental arrears over the past several years, pre-pandemic. We would carry, we had to write off each year about $200,000 of rental arrears. The last 2 years, it's been $900,000, especially in our shop. Those are resources that we're not able to collect, not able to put toward our mission. In the last 2 years, we've increased our spending on security. And we have a staff person now, that's the director of security. We spent probably $400,000 or $500,000 last year hiring sheriffs to walk the halls at night in some buildings, when it's going to. If you told that's some of our properties, we hired one of them, purchased one of those blue lights that we could park in parking lots to just attempt to deter some of the activity that's going on. So it's a real cost to us. But what keeps us up at night is not community deaths. The violent and what we did out of our buildings and away from our victims. In our shop alone, we have 68 units.
I'm just wondering, are the units you have primarily sort of buildings of all low income people with disabilities, or are they more scattered around? Do you know what I'm asking?
Most of the apartments that we have are income restricted.
Mhm.
So people have to earn a certain income or less. About half of our apartments come with some subsidies, so they're very low income people. About half are just people that are working and just not making wages enough to find a property market.
Okay, but so it's a building full of people either in poverty or so it's not mixed income or mixed ability. It's
There will be always some mix of income in the building, a small number. So say 20 unit building, there will be 3 units that will be unrestricted.
Okay.
People of any income, but then the rest would be some kind of restrictions. So we try to mix. In our portfolio, we have about 60 or 70 that we flagged as a concern in terms of the safety of our staff. And so we, if we need to go in and fix a sink, do regular inspection that we need to do, or get paperwork filled out, in those apartments, we will bring along 2 people. Do that. All the organizations of the state have a similar list. In addition to that, we have 12 to 15 that we will not go in, we will not allow staff to go into because of the safety concerns. Whether it's drug dealing, with guns, with some other kind of violent behavior. And again, we provide a lot of social services to folks, so it's not mental health that's the challenge. I mean, it's a challenge, but that's not what's keeping us from providing support to our tenants. We are providing that support to tenants, we're connecting them to other services. It's when things are violent for criminal activity. So there are implications on our staff retention and recruitment to do this work. Also, because of the freaking, and this is driven law from the version of the law 5 years. Under the current law, when this gets to the notice period in the court process, and this is why this is really important to know. Under the current law, if you are living in an apartment, you don't pay your rent, there's a 14-day notice period. It's current law. And then if they stay in the apartment after the notice period, you get a hearing date, you get in progress, and that has a target of 180 days. That's a good quote. That's not 80% of the time, 20% of the time it's not for various reasons. If you're in the apartment next door, and you are engaged in criminal activity, being burns, what have you, you get in the current law, you get a 14-day notice. Then when you go to the court process, if you stay there, then you have the same schedule with the courts. There's no distinction between the behavior of non-journalists and this true activity, and that's what we want to fix. That's the thing we want to fix. That's what keeps us up at night. Because those, if you're not paying rent, we'll work with you. We'll try to figure it out. We'll access resources. Do whatever we can. If you're engaging in criminal activity, we need to connect the other people that are in the building, and that's why we want a faster process. It's simple and black and white as that for us. The other provision in the bill is really important, and I brought this up earlier, is the no trespass provision. Oftentimes, people that are vulnerable are more susceptible to being preyed upon by others, and people that we have found that have taken over folks' apartments and they're too scared to actually take action, or they are the best substitution disorder and it's satisfying their needs that way. And so for us to be able to step in and no trespass people that are causing havoc, sort of building, breaking doors, breaking the locks in the doors, letting anybody in and out throughout the night. It's really important for us to be able to do. And we don't take that power lightly. It's only to have health and safety. If you wanted to say safety and not health, because I heard the chair talked about people that smoking in the hallways, it happens on health. But the activities are affecting the safety of our residents. I think we have an obligation for that. And right now, the law does not allow us to develop that. The expansion of the effective date, I agree with people. And again, I've been watching through this bill, through this whole body. It's never been committees. I've been hearing a lot of the testimony. I understand and I agree with a lot of it. Background credit checks. Should be done to be charged for those. It's never in that condition. Effective date, push it out 3 months. This is out, a lot of these start up September 1st. This is out, that's fine. We're totally amenable to modifications, but I also understand narrowing the bill to make sure that it really focuses on those things that are going to become daily. Is our number one priority.
Okay, for questions. Any questions? Senator Miles.
Chris, I heard numbers about security and also not being able to get into a unit and there's violent activity. Do you have like a total between security, maybe repairs that have been done due to damage, or even in the in the unit itself, say you had a shower valve leaking and you're not allowed to access the unit and it affects 2 other units below. Do you have an idea of how much?
Last year we wrote off about $900,000 in, not just that rent, but also damages that we just knew without the. And so that's a number for the game, the property, but it's that, on the home. And the security is separate, and try to share that across our portfolio. And that's been up between 4 and 500,000.
Maybe $1 million in damages.
Yeah.
Not including the rent
Right,
part,
yeah.
but who knows?
Something like that. So, we can I can go back to the office, dig back into the distinctions between those numbers, but we often, someone said this to me in my office, and I want to verify that this was fantastic, but they said, we never use a kitchen case. We don't do these lightly. We only pursue, I think it's more than only the win, but that doesn't mean that we collect the damages or that.
Any other questions? My question, I might have 2 questions, but the timelines on for some of the other processes in this bill that's passed by the House, can you describe your opinions on those? I know you talked about the expedited hearing, and I get that, but there's some other changes in other areas of the law regarding notice and all the different timelines. What are your thoughts?
So for non-payments, current state law is 14 days. Up until 2 months ago, all the nonprofits under federal law had to wait 30 days because of the Federal CARES Act. And so we weren't even doing 14-day notices up until a couple of months ago, and the Trump administration rolled that back. So for us to go from 30 days to 14 days, okay, we don't need to go. I don't think we would need to go all the way down to 10. That's just our position is that's not a big change for us. It's already a big change for us. At least we go from 30 to 14. The notice for the breach of contracts between 30 and 21 days. Again, I really feel the thing that keeps us up at night is the violent behavior, and I'd rather put my money on really fast for those 6 seconds. I'd rather urge you to say we need to focus on that. The other breach, hopefully you can deal with some of those things with more intense. So I don't have a strong opinion on going from 30 to 21 days. But going from 14 to 5 for the violent activity, and I think there's no language that we can be more particular about the specific federal language and actually what we're talking about. That would be helpful. Then the illegal drug activity, coming back in criminal activity, getting rid of the word health, safety. Threatening was in the before threatening was in the law. This is just for now. We still have to go through that before to get rejected. So that we're going to provide the evidence. And this new language in the bill that requires us to provide the kind of actually the facts that you have to use of this new system. So this, that's on the notice on the court process. I heard Terry Gonzalez when she said they can do the expedited process for threatening behavior and threatening activity. That they can meet that 21-day process with the existing structure that they have. That made me feel comfortable saying yes, let's do that, because that makes us be able to address it faster. I also heard her when she said 90 days making it hard, because then we're kind of competing with other things that the civil court does. And so if that's too difficult, I prefer to their expertise. I'm not a lawyer. I think I just know what other states do. And I think this was mentioned before. If we can think about a different process, so that it's fair for tenants and faster for landlords, then we should do that. And if that's what we have before.
And the 90 days, just to refresh everyone's memory, that would apply, that would be the 90 days notice, or if you're selling the property.
Oh, I'm sorry, yes, that's the other, I didn't mention that one. Sorry, I was talking about the court process, the 90 days for here.
Yeah.
Was the count, so the 90 days for, I think that's a great tenant protection. Right now, the biggest barriers to finding housing for people is time and money. And so if you are being asked to leave, at the end of your lease, not in one of our shops, but just in a market, and you have 30 days in some cases, that's really a short time to be able to turn around and find first month, last month, security deposit, and move into some place within 30 days. So I think standardizing those at 90 days, I think it's good public policy. You know, you're say that's too much. From my perspective, I would okay that.
That's when the final, just want to make sure. So if you're talking about non-payment of rent and breach of contract,
Yeah.
you got a notice, and then if the tenant stays in there, this would propose to have that final hearing within 90 days.
That's an ejecting process. I've been going back and forth. I'm sorry, and both say 90 days. So it's the termination of a lease. So at the end of your lease, the landlord says, actually, I don't think I want to rent, you know, this is the no cause condition, right? Or I'm selling the property, or I'm renting to my vendor. That has a 90-day notice period in the bill right now. That's a notice period. The 90 days for the rejected process was a target that's here for the court process. So I don't work. And I think that's what I would defer to the court process. I would defer to the courts to say what's possible and maybe find if there are other resources needed for the courts to do things faster. For the termination notice, the roots termination, early, I think that's reasonable.
Yeah, I think so we are getting, actually, Emily, could you print the disposition dates that Harry sent along, or did you send it along? Well, we were getting some information from Terry about different disposition timelines. I hesitate on making the final hearing requirements and setting timelines for those. Not because I think cases should take a long time, but rather, you know, everybody's case is very important to them. And, you know, the person who gets hit by a car and they have a negligence suit, you know, sure they want their case heard within 90 days or sooner as well, than, you know, other contract violations and so on. So I just worry about opening a door to creating strict timelines in which the court shall hear a certain case, if that case doesn't necessarily involve you know, violence or, you know, like TROs, RFAs, and so on. So that's just my initial take on the.
And I think I'm going to agree with that. Okay, I agree with that. I heard what the court said. So if it's a violent situation, let's do it. Let's move quicker. And if not, then it's with the rest of the document.
Thank you. And one last question, that this might be more of a question for ledge counsel, but on the trespass piece, I'll just find my things here. So I'm looking at page 25 and subsection C, the invitee or licensee is violated state, federal law while on the premises of the dwelling unit. And when considering the definition of dwelling unit, if the invitee or licensee is in a common area or the parking lot, of the building, but not necessarily in the dwelling, and they're violating state or federal law, how would that work?
I think premises is the keyword that I prefer to. And I'm happy to hang out here too, if you have questions while you go through markup, and if you want to follow me in the front end, and I have been following this bill.
And one last question that I had, the expedited hearing. Page 8, line 19. Threats to the neighbors.
Oh, yes.
I think, I understand what it's getting at. What I would hope for clarity on is, well, what is the definition of a neighbor?
Right.
I know, I live on a dirt road, and I consider somebody a quarter mile up the road to be my neighbor. But, is somebody in a neighboring building also a neighbor, or is it an apartment building that is adjacent or maybe on another floor? And so I wonder about the clarity or lack of clarity in that definition. So I'm wondering if you have any thoughts on that, or we can also.
Yeah, my thought from just the experience that we've had, and in fact, one of our partners in Berlin last week had someone take a telephone and shoot out the window and hit windows of an assisted living facility that was in a neighboring building, and hit a person. That person had been under eviction process already. And so that's so, when we think about threats to neighbors, we have a street in Burlington where there was a woman that would harass all the kids to the point where they didn't feel safe being on the street. Because those was violent, threatening behavior. So, I agree, maybe there's a tighter definition. I think it would probably rely on a couple of cases in the courts to agree with that community. So, or if you think, yeah.
Any other questions? Okay. Well, thank you very much, and you're welcome to stick around. Okay. All right. So if you want to just end, Emery, maybe. Okay. So we're going to go in through markup now, and for the sake of transparency, yesterday I met with the chair of economic development, Senator Clarkson, and as well as two stakeholders, Pledge Council, Chris and Chad, and the realistic, well, trying to be realistic with this bill and focus on the priorities. And at least personally, and from what I've heard, it would seem that the priorities for this bill are the expedited hearing and the no trespass. And so what we discussed were a list of amendments, all of which are included in this new draft. And it is with the purpose to narrow things down and keep the bill focused on those two important components that I've described and that we've been hearing about this morning. And so that's what this draft 1.2 contains. And so it is a strike all, right? Yes, sir. And I want to make sure that we're going through all those different changes that Senator Clarkson and I discussed, and getting the committee's opinions on them. And of course, this does not prevent anybody else from providing any other amendments or any other input that they want to provide. That is, that's where we're at. So if you walk through all the amendments and level set.
Yes, sir. I'd be happy to. For the record, Cameron Wood, Office of Legislative Counsel. As the chair mentioned, I have a draft amendment from the committee. It is drafted as a strike all. What I've done is I've highlighted areas in the bill where things have changed However, there are some deletions as well, and so I'll point those out as we walk through. So. The share. So the first change is actually going to be right on page 1 under the definitions section. The changes to the definition of actual notice has been removed. So if you all recall, when you're terminating a rental agreement, so we're not in the court process yet, we're not in the ejectment, we're just talking about when you terminate a rental agreement, the parties have to provide actual notice. And actual notice is currently defined as hand delivered or mailed to the last known address. And if it's mailed to the last known address by certified mail, then it comes with third certified or first class, then it comes with a rebuttable presumption that the person has received it after 3 days.
In an instance, I know this has certainly happened to me. I mail a bill to clients and weeks or two later it returns to me because it was undeliverable. How would that?
So at that point, I would say the landlord, I'm just going to use the landlord, this example is mostly going to be a landlord. The landlord would know that the individual hasn't received actual notice because the definition of actual notice requires receipt. And so if it comes back undelivered, the landlord knows at that point that you haven't received the actual notice. And the landlord would then need to go about trying to effectuate that service in a different way. So the landlord would know they wouldn't be able to proceed with an ejectment at that point.
Okay. And I'm just trying to understand the sort of timing of it. I imagine we've all heard from constituents about the slowness of the mail at times. And so there's this presumption that it's been received within 3 days, but if it doesn't make it to be undeliverable for a week and then it doesn't make it back to the landlord for another week, are there proceedings that can happen in there under the presumption that it has been received? Because it's not in the landlord's hand in that 3-day window that they didn't receive. Do you see what I'm?
Yeah, absolutely. So the landlord wouldn't be able to proceed with an ejectment until after the notice period that's required in statute. And so currently the shortest notice period in statute is 14 days. And so you can't proceed with the ejectment until the notice period is through and then the person remains in the property after the termination notice. So as the current statute is structured, you provide the notice and keep in mind, you have to give them the 14-day period from the day they've received it because that's the requirement.
So it's
if you
17
mail
days
it,
after mailing.
yes, ma'am. If you mail it, you have to build that time frame in. And so if you had received something back as undeliverable within that notice period time frame, you would then you'd be aware that the person hadn't received it and you would have to move forward with trying to provide notice again. If you move forward with an ejectment, let's say you haven't received that information back and then you move forward with an ejectment and then later on you become aware that the person hasn't received notice, then again, have to start over again.
Okay.
So, 2 questions. First one, I'm losing track of what the 3-day rebuttable presumption. What is that 3-day?
So when you look at the definition, again, it requires the person receive it. And so when you hand deliver something to someone, you obviously know that they've received it.
Yeah.
If you mail it, you know they're not going to receive it the day that you put it in the mail. And so you all, as the body here, have built into your statute that we're going to create a rebuttable presumption that the person's going to receive it 3 days after you mailed it.
How would you rebut that presumption?
The individual defendant would have to come in to court, let's assume it's got all the way to the court process, and they would have to demonstrate and provide evidence to the court that they did not in fact receive.
How do you prove a negative? How do you prove they didn't receive something?
There might be a better question for the advocate that they could give you examples that they've gone through, but that you were able to demonstrate that the landlord mailed it to the wrong address because it's being sent via certified mail and we're able to show that you actually mailed it to the wrong location.
No, that would be easy enough. I'm thinking somebody gets it within 3 days, they throw it on their kitchen table, and then they deny that they received it within 3 days. They say it came
So it's on the defendant. It's a rebuttable presumption. So the presumption is that the person received it. So the tenant or the defendant in that case is the one who's going to have to provide the evidence to the court that they didn't receive it.
I just don't see how what evidence is there?
Perhaps you could show evidence that you were hospitalized during that time, and so there was no way that you could have received it because you weren't there.
Right, I mean, you can think of like extreme cases, but in the main, if somebody doesn't, they don't get it. They go into court, they just say, I didn't get it. There's no evidence brought forward, right? So I think it's odd that they have to reflect something where it's hard to imagine in most cases any evidence, but
Yeah.
anyway.
Well, again, you have the evidence that, you know, the person is going to receive the receipt or the notice when they put something in the mail certified, right? Your landlord, you even, best practice of ensuring that you had some sort of return receipt requested back. You have even further evidence that someone at the location had actually received that document. That could be something you could demonstrate or prove in court.
But it's not the landlord who has to produce evidence. It's the person receiving it.
Correct.
So,
It's the person, if they're arguing that they didn't receive it, then they
Right.
would have to.
but I mean, there's no incentive for the landlord to get the receipt because they have the rebuttable presumption that you got. So you have to come up with evidence.
No,
You didn't get it.
It's in your best interest of the landlord to ensure that you can prove actual receipt when you get to the court process, because if, let's say, for argument's sake, that the defendant is able to demonstrate that they didn't receive it, well, now you haven't provided notice in accordance with the
I just don't
statute.
understand how somebody proves they didn't receive it. Other than saying I didn't get it, what evidence is there that you didn't get it?
Again, I haven't practiced in this area, so I'm not familiar with what unique circumstances could exist that.
I've seen Chris's face. I'm sorry, this is what the current law is. This is how we operate right now. And so if a tenant wants to come and try to make that case in court, they can. But this is how we operate under the current law.
Okay.
Just to circle back around, the amendment is proposing to not change anything with the current system. You have questions about the amendment to keep things the way they are?
I just have questions about why the rebuttable presumption is on the person who didn't receive it. When the person sending can easily create evidence that they sent it, the person who didn't receive it can't create evidence that they didn't receive it. Anyway,
I think the issue is you're requiring that the individual receive. And so when I put something in the mail, I know that the person hasn't received it. So if you're going to allow that, if you're going to allow the mailing of the notice, you then need to determine, okay, we have to assume based on that structure we're creating that the person receives it at some point, and at what point are you going to draw that line? Because you're assuming, right, that you put something in the mail, the postal service is going to get it to where it's supposed to be.
or we could require notice of delivery. Right?
You could remove mailing and just require hand delivery. So you could do that.
So, Norris, you had a question?
This is very interesting. I'm kind of leaning toward the first class mailing because I don't know how you approve that you as a sender actually mail it unless you ask for a return receipt. Right. And here's the reality. They're going to avoid that. Okay. Believe me, they're going to avoid that. So it's first class mailing, totally, I love it. I like that standard.
I don't believe that it is.
Yep.
Because as a landlord, you're gonna send it and get a receipt back, maybe, to make sure on your end, because if somebody comes in and just says, oh, I never got it.
Yeah.
And the courts go, well, they never got it, so we're gonna assume they didn't get it, and the landlord go, actually, they did on this exact.
And I agree with you. The law doesn't require them to ask for a receipt. And it puts the evidentiary burden on the person who didn't get the notice. That's all I'm saying.
I love this conversation. My question, knowing this is underlying law, is do you know when this was put into underlying law and 3 days was chosen?
I do not off the top of my head, but I
Okay.
can find out.
That would be great. My concern with the sort of 3 days is the current state of the postal service. And whether or not it is reasonable to assume something actually has been received in 3 days at this point. So I'd love to sort of get a sense of what that history is and perhaps what the sort of average time of delivery is. And I also would imagine that it's different if someone mails, if, you know, I live in Burlington and my landlord lives in Shelburne versus if I live in Burlington and my landlord lives in Florida.
So,
Okay.
for this, so, okay. So I suppose just keeping things the way they are. Sense somewhat of what I'm getting from the committee is potentially requiring first class mail rather than just putting a stamp on an envelope and sending it off. So and go into the 5 days. Is that
Well, quite a few.
okay? So you don't want to do first class.
No, I'll just inquire the conversation was taking place. I'll find a few people where the
And
Okay.
to go along with that, I think I don't think it makes sense. We're in the process of trying to limit what we're doing to current laws for time and other reasons. So I'm not suggesting that we redo the existing law. I was trying to point out what I think is an unfair aspect of it. Okay.
Yes, I might suggest expanding from 3 to 5 days. Based on the information I get about when this was written and how it aligns with the sort of average amount of time it actually takes for mail.
So
So you still have 14 days after that as well, so it's 17.
So then the amendment of striking section 1, how does the committee, is committee yes or no on striking section 1 in the bill as passed by the House?
Yes.
Great.
So just a question about the rebuttable presumption, I'll get you some information back on that. Okay. The next piece is going to be in the definition of actual and imminent threat. And this is to change serious bodily harm to serious bodily injury, and then to refer to potential injury throughout the remainder of that section. I believe that was raised by Judge Zone. Makes so that the phrasing of that aligns more with what you have in the statutes.
Any opposition to this?
I do have a question as it pertains to, is this the definition that will apply to the later section where it talks about the sort of expedited?
Okay.
Okay.
Next change is going to be on page 4, where there's actually been some pieces that have been removed. So you're not going to see any highlighted language here. This is about the residential rental applications. Actually, it would have been moved up because I deleted it. My apologies. It's going to be on page 3 now of what you're looking at. It's page 4 of the bill that was passed by the House. Sorry, I was on bill. Keep my notes together. Okay, residential rental application. Current law is that the landlord cannot charge an application fee. And then this provides a definition of an application fee. And then if you all remember, there were 2 sections in there that a landlord could charge the actual cost to conduct a background or a credit check. And if they charged for it, they had to provide the applicant with a copy. And unless the applicant provided the landlord with a copy of a credit check, and then the landlord couldn't charge for it, those 2 provisions have been removed from this section. In addition, there was some language in there that stated that a person who violates this section commits an unfair practice in commerce, and then referenced back to the Consumer Protection Act. There's actually been some case law in Vermont that the landlord-tenant relationship under Title IX, violations of that could be already a violation under the Consumer Protection Act. So I don't think you need a specific call out there because the courts have already determined that they fall, or that, you know, you can argue that those protections already apply. And so we just removed those 3 sections. One comment I will make to you as you want to move forward, and I was thinking about this while I was sitting here this morning. I think one of the biggest issues with this section is the fact that application fee wasn't defined. And so now you have a definition, but I still think the underlying disconnect may exist. Is a background check or a credit check an application fee? Or is it something else? I think individuals will argue, well, if you're charging me to be able to file the application, then anything should be considered a fee. And I think other people would argue, I'm not charging you a fee to submit the application. I'm charging you a fee at the next step to do the background check or the credit check in order to determine whether or not I want the rent to do. I'm bringing that up to say, if you want to ensure that people are not charging for a background or a credit check, then I think it may be worth it to add it into that definition to be explicit.
Any comments or questions?
So being explicit, does it mean you can charge for like a background check?
If you, what I would say is, it's the background check or credit check is not used in that definition because the way it came over from the House, the bill specifically authorized charge for it. And so my point is, if you're going to remove that authorization, the language that specifically said you can charge costs for this, if you're removing that, I think the ambiguity still exists now to say, is a background check or a credit check an application fee? Or is it something else? And if you want to be explicit that we don't want people charging for a background check or a credit check because we consider that to be an application fee, then you may want to add that specifically in other words.
Any other questions or comments?
I would certainly support that sort of more explicit language, but I do have a question that's about this section, but in sub 2, which is a little out of our wheelhouse. But I'm noticing there is this language that says you can't charge a security deposit exceeding 2 months. There's some municipalities like Burlington that actually have stuff in their charters that say you can't charge a security deposit exceeding 1 month. Would their charter hold that protection or would this override it?
Yeah, so I've mentioned this in the Senate Economic Development Committee, and I don't think we got into security deposits when I did my initial walkthrough of the bill, so I didn't mention it here. There is a section in the there's a subsection in the security deposit section that says that a municipality can enact ordinances related to security deposits as long as, you know, they essentially, I don't remember the exact words, they don't conflict with the minimal protections that you put in. I think an argument could be made that by putting in the state statute that a landlord cannot charge more than 2 months rent, that a municipal ordinance that says you can't charge more than 1 month's rent may be in conflict. The court could make that determination. So one thing it may be worth adding is some clarification in that section to say that a municipality that has kind of more or greater protections for tenants when it comes to security deposits would not be a violation of that section. So
Let's put a pin in this section so we can get to the more substantive pieces and then we can circle back around to it.
the next change is going to be
Is it page 7?
I believe so.
Yes,
Yes, sir. Yes, sir. Thank you. I'm sorry, I'm looking at this number. Okay, this is the termination notice section. So this is where we talked in the past. You have subsection A, which is where you have a notice requirement if you're terminating for non-payment of rent. Subsection B is when you're providing notice or breach of the rental agreement. And then the changes here are on sub 2. So the proposal here is to keep criminal activity, keep the strike through for illegal drug activity, keep the inclusion of damage to the dwelling unit, but then it removes the phrase that the House went with, which was other activity. which threaten the health or safety of others. So you've removed that. So you're really keeping with the current statutory language. You're removing drug activity, you're adding damage to the dwelling unit, and then it would have to be an act of violence that is an ongoing or repeated threat to the safety of other residents. So as you can see, you have a few other tweaks to the language there. It would have to be ongoing or repeated, so it couldn't be one instance. And then you removed health, so it would have to be the safety of other residents, the landlord, landlord's agents, or neighbors.
Quick clarifying question about existing law, just going back up to line 8 and 9. Currently, can you, say there's a breach of a rental agreement if the tenant is late once in a 12-month period, or late once in any time period, and then move forward with the eviction?
I haven't found a case that makes that argument, that late payment of rent is the breach of a residential rental agreement. I think the issue that you potentially run into is the language in subsection A, the language in the objective chapter that says that if a tenant pays through a rental period, you can't terminate for non-payment of rent at that point in time. So let's say I'm extremely late in paying rent. I'm 14 days late, I'm 20 days late, and then the landlord wants to move forward with a termination because you haven't paid rent, and then I subsequently pay rent, then it cancels out that termination and you can't move forward. And so
being legal aid, you raise your hand.
For the record, Jean Murray from Vermont Legal Aid, your question was, does current law allow a landlord to terminate an agreement for late payment of rent? So one of the things about the Residential Rental Agreements Act is it says in itself that everything in the RRAA is imposed in every rental agreement. And one of the provisions of the Residential Rental Agreements Act, 9 VSA 4455, I think, requires rent to be paid without demand at the time and place agreed upon by the parties. So if a tenant doesn't pay at the time and place agreed upon by the parties, that's a violation of the act, and a tenant could technically be evicted for cause for that.
So I just want to be super clear with what I'm trying to understand. Currently, the tenant misses 1 month, the eviction process can start. This would change it so that if a tenant misses at least 3 payments in a 12-month period, then the eviction process can start for not paying the rent. Am I? No,
not misses.
Two
late. Okay.
two different things. Whether or not the tenant abided by the agreement and paid on time. And then the second thing is whether or not the tenant is behind on rent. And in that way, it's sort of the landlord's choice. If the landlord is going to send a termination, it gives the tenant a right to cure non-payment. That means what the landlord's basically after is to get paid. Where if the landlord is trying to terminate because the rent is paid late, landlords, that's what they're trying to do. So it's 2 different things.
I don't want to derail this too much with the question that I thought was going to be.
I agree with Gene 100%. I would say that by putting this language in the sub 2 into statute, you all would be indicating that a landlord wouldn't be able to move forward under B for a late payment of rent unless it was more than 3 times in a 12-month period. I think, I don't need to speak for Jean, but as I'm hearing her, and as I would agree, the landlord could in theory move forward under B for late payment of rent once because you've reached your obligations under the chapter. And by putting this language in, I think you would be signaling to the courts, hey, you can't do that anymore. it has to be 3 times within a 12-month period for you to move forward under B. You may be moving forward subsequently or at the same time under A to say you have paid rent. That's why I want to determine.
That makes more sense. So,
By law, is the lateness determined by when the check was put in the mail or when the check was received? So if I mail my landlord my rent, do I also get a rebuttable presumption that it arrives within a certain, do you know what I mean? Like, I might have mailed it on the first of the month, but that doesn't mean it arrives.
Right. I do know what you're saying, and I don't believe the statute says anything in relation to that. I'll go double check. I don't think the section that was being referred to, because you have to pay rent on demand, says anything about actual notice and rent received.
Okay, so there's nothing sort of indicating that rent is on time and was postmarked on the due date.
Not to my knowledge.
Bruce,
I'm looking at page 7, line 8. A tenant's late payment is a reason to terminate. Tenant's late payment of rent more than 3 times, so it has to be 4 times at least.
Correct.
Sounds like a lot of time.
Well, I think one of that may be at no fault of the tenant if they put it in the mail every time on the first of the month. And the post office takes 2 weeks to get it there.
we'll come back to this. Let's, go back to the changes.
Okay.
Please.
Back to the sub 2, you would be keeping criminal activity, which was struck in the House version. You've removed other activity. So now it would be, based on this amendment, it has to be criminal activity, damage to the dwelling unit, or an act of violence, which is an ongoing or repeated threat to the safety of other residents, or landlord agent, or neighbors.
Any, yes,
I'm just trying to understand the sort of logistics of this. So if any one of these things happens and it is an ongoing or repeated threat.
Correct.
Okay, so it can't just be that. I don't know, I accidentally ruined the carpet. It has to be damage that is also an ongoing and repeated threat to the safety. And then how is that sort of threat to safety defined? What does that mean?
It's not defined in the statute currently. And so it would be, a court would have to make that. Let me back up. I mean, the landlord is making the initial assessment of whether something is a threat to the safety of others, because the landlord is making the initial determination of under which statutory section they're choosing to terminate the rental agreement. So the landlord has to make the initial point to say, I'm terminating the rental agreement under B2. And then the landlord ultimately is the one who would have to prove that in court if it gets to a different action. And a court would have to make a finding that, yes, the activity in question was a threat to the health or safety of other residents, as the current statute should.
any other comments, questions? I think, Cameron, one of my questions that I had raised earlier, regarding phrase or the term neighbors using this. Can we take a deeper dive into that? But also just a note for our witnesses for our next bill. We are running a bit behind with the fire alarm, so we're running a bit behind, so you're aware. But yeah,
Similarly, neighbor, it's not defined, so of course, we're probably just gonna look at a plain language reading of that. And I think it would be a challenge for a landlord to be able to argue that something that the individual is doing is threatening the safety of a neighbor who is half a mile away. So then again, it's going to depend on what activity are we talking about. Is the tenant, making bombs in their apartment, right? I think it's pretty to use the example provided. Is the tenant firing, some sort of weapon at the location of some neighbor that is, a neighbor mile away, that is, hitting the property and stuff like that. I do think it's gonna be pretty fact specific, but it's not defined, so.
I'm wondering, and this is really a question for you, who would be the right person to come in and sort of walk through some of the ways those facts might come together? Because it seems like there's a lot of questions in here. What's a threat? How does it like all play together? Would that be the state's attorneys?
Well, I mean, a threat, I mean, whatever is being alleged will ultimately have to be determined if it is actually a threat by a judge. Somebody spills coffee and ruins a carpet, and the landlord says, this was some damage to the property. They send that affidavit to the court. Judge is probably going to say that's inadequate.
And I would say, keep in mind, I mean, there are two conditions that the landlord has to prove under current statute. It has to be criminal activity, it has to be illegal drug activity, or it has to be an act of violence. It has to be one of those things. And then you have to demonstrate that it is threatening the health or safety of other residents. So those are kind of the two separate conditions that would have to be demonstrated. And same thing here, it would be criminal activity, damage to the dwelling unit, or acts of violence, any of which, based on this amendment, you would have to demonstrate that it's an ongoing or repeated threat to the safety of other residents.
Yeah, and I know that I used the sort of spilling the coffee and ruining the carpet, and that was when I was trying to sort of understand how the things hinged together, which I do now. But I also know that there is behavior that is not dangerous, that people at times perceive as a safety issue when really it is making them uncomfortable. And one of the examples that I used earlier was if someone is in their apartment and they may be screaming and they are, maybe not existing within consensual reality. So they may be screaming things that make people really uncomfortable, but in no way is their safety impacted. But they may feel like, oh, this makes me unsafe. Okay. Or I used the example earlier of, an individual whose existence makes people perhaps feel unsafe. And I understand that the courts are there to determine that. I'm just trying to understand sort of how that plays together and make sure that we're protecting people from bias.
And so what I would say is, the House version, when it had other activities, I think that obviously more open to more subjective interpretation of what activity are we talking about. In this version of the amendment, you're going back to how the language is currently, which would require it to be criminal or an act of violence first, right?
Or damaging to the dwelling or premises.
Correct, yes. And so I do think this language is going to be more restrained in addressing some of those possible scenarios that you've identified, that others have identified based on that House language. If someone is just making others uncomfortable, is it criminal activity?
Well, it might be disorderly conduct, which is very vague and open to subjectiveness.
Straying into areas that are not mine. But it would have to be a criminal act or an act of violence first.
Okay.
Any other questions or comments on this section and written? So, is there support or opposition? What's one of you?
I think I support this language more than what came to us, but I do still have some questions as to whether or not it's tight enough or might need some additional definition or clarity.
Anybody else? I'm sorry.
Perfect. So, just as a heads up, I think we'll spend another 5 minutes on this and then we'll shift gears to our witnesses for this one as well.
Okay, I will try to be quick and succinct with the remainder here. Quick, succinct. The next change is going to be on the bottom of page 15, moving to page 16. There was, you see there's a section 2 deleted. there was a section in the as passed by House bill, and it stated that when a motion for alternate service of process is filed, so keep in mind, now we're in the court system. Ejectment action has been filed. There was a section here that said when a motion for an alternate service of process, so you're not able to effectuate service on the individual, you're asking the court to allow you to do some sort of alternate service, potentially attack order. It said that the court had to rule on the motion promptly. You had some feedback from Judge Zone about, what does that mean? Concerns about putting the word promptly in this situation. Words, should have a meaning. And if it's prompt in this instance, does that mean it doesn't have to be prompt in other instances, etc.? So I removed that section. And then for the next pieces here, the House passed version created an entirely new subchapter for bringing an ejectment based on non-payment of rent or the kind of threatening acts that we were just talking about. This amendment removes that new subchapter. It takes all of that new subchapter out. If you remember when I did my walkthrough, I highlighted for you all that probably 85% of the language in that new subchapter was simply copy and pasted over from the existing subchapter. And so if you want to duplicate and create an entirely new subchapter for potentially very minor, minor changes for a few sections only. So I removed the old subchapter, and what you have here is I've amended current section 4852 to add in the language on line 13, where if a landlord brings an ejectment action under the current subchapter, the landlord has to include the affidavit that the landlord provides to the tenant for the justifications as to why they're terminating the rental agreement. So because that affidavit requirement is new, it's being added here, that has to be included with the complaint. Then we get to the next change, which is payment of rent into court. And this is going to be on page 17. If you all remember, the House version struck the ability of the court to order partial payment, required full payment. So that's back in. So it's giving the court the discretion to order full payment of rent into court or partial payment of rent into court, as the case may be. So it's just removing those two words that were struck. The other thing it deletes is because the House version was removing the ability of the court to order partial payment, they wanted to add in language to authorize the parties to come to an agreement for a reduction of full payment. And that's being removed here. Because you're allowing the court to order partial payments, you also have subsection G, which allows the tenant to request a reduction of the amount paid at any time. The parties come to an agreement at any time, and I imagine the court incentivizes or tries to get parties to come to an agreement. So that has been removed as well. The next change is here on the threatening behavior expedited hearing. So as I mentioned, I've removed the creation of this new subchapter, but you kept this, the amendment keeps this expedited process for the threatening behavior. And instead of putting it in a new subchapter, it puts it in a new section within the existing subchapter that's already governing ejectment actions. So go under 4853C. All of the language here is kept as it was in the House, except we've removed threatening the health or safety of other residents. So as you can see there on lines 8 to 9, it's threatening the safety of other residents to coincide with the change above the termination section. In sub B here, it said that a hearing on the motion shall be held promptly at any time after 10 days. I removed the word promptly because it didn't really seem relevant, because you're specifically saying that the hearing has to be held after 10 days and no later than 21 days. That's the window. So I removed the word promptly. I think there is only one other change. And it's all the way down on page 27. There's a section here because you cap security deposits above. And this section said a landlord may retain a security deposit that exceeds an amount equal to 2 months' rent, provided that the agreement was in effect prior to July 1. I was somewhat concerned about the word retain. I didn't want it to be interpreted that a landlord could just keep it. The concept here was if you've accepted more than 2 months of security deposit, when the 2-month cap goes into place, you can keep that. You don't need to immediately give some of that security deposit back. You can retain that amount until the termination of the rental agreement, in which case you need to comply with that section and give the money back to the tenant or deduct if there are legal deductions that are authorized. So just really more cleanup to make sure that section is clear.
Thank you. So, committee, if we have any other questions, how to get in touch with Dan, but we're going to be working on this first thing next week as well. And if there are other changes that anybody wants to propose, we'll do that. But we are on a pretty tight timeline for everything. So we're gonna thank you. We'll switch gears now. We have Haley. Or no, I'm sorry. We have Jen Pullman first from the Victim Services. I'm sorry, Center for Crime Victim Services. And we're switching to the miscellaneous.
Good morning. For the record, my name is Jennifer Pullman. I'm the director of the Vermont Center for Crime Victim Services, and I appreciate your time on H 937 today, and also appreciate your flexibility during school vacation week. I will be brief. I understand that there's a particular interest in hearing about victim notification, and I believe Legislative Council has drafted some language for inclusion in H 937. So I'll be very brief in giving the background to that. As you may recall, the Victim Notification Task Group was established last legislative session to look at ways to improve victim notification. Particularly, we're looking at post-conviction and also the use of the automated victim notification system, but we did look at post-detention and victim notification in other areas as well. And I do want to say that the group was comprised of the center, the network, the state attorneys, the Vermont State Police, 2 members from the Department of Corrections, and 2 survivors. But we had a lot of active participation from non-task force members, including disability rights, many advocates from the State's Attorney's Office, from VSP, and also other DOC staff members. So it was a really robust group. One of the areas of focus, I'm just going to get right to it, was looking to bring back what we referred to colloquially as a menu of options. The VINE system can provide a number of different notifications, and corrections is engaged in a lot of different activity with those who are in their care. And several years ago, there used to be more of a menu approach to those notifications, wherein a victim survivor could choose which notifications they were interested in and which they weren't. And maybe they weren't interested in any at all. Because some of the different notifications, speak to release of someone, any kind of transfer, either to court or a different facility, parole notification, earned time. And some victims don't want anything. Other victims want every single thing. And the system used to accommodate for that, but we went away from that as a state. And it became more of an all or nothing. So the hope was that we would be in a position to return to that approach. We heard from victims and survivors and from advocates that it was really important to restore some level of agency and choice and control of the information that was received. We were working, or I should say the DOC staff were working with the vendor to get this option back in place. And the last update was that it would be available potentially the end of this calendar year. but we came across a stumbling block, hence the recommendation, the language that you see that Legislative Council has put together. That stumbling block was currently in Title 28, which speaks to DOC's obligations. They don't have any ability to not provide the rights therein. So those rights have to be provided. Whereas in Title 13, which speaks more to the state's attorneys, victim advocates obligations, there's a blanket statement in 13 VSA 5304B, which allows a victim to decline any service that a victim advocate offers. And DOC was of the position, and we agreed and understood that if they don't have that option to not provide the right, that it would put them liable if they were not providing it without change in statute. So we all agreed as a group that it felt important to put in Title 28 a statutory provision that would mirror what's in 5304B, Title 13, 5304B, giving victims that choice to be able to opt out of certain notifications. And really felt like an important way that we could support DOC's staff and their victim services unit in meeting victims where they're at and having a more individual approach to providing support. So again, the language that was drafted by Legislative Council perfectly encapsulates our consensus collective recommendation for change, without which we cannot move forward. And DOC could not move forward with instituting something that has been identified by victims and survivors from across the state as a really important piece for them in terms of being able to best utilize victim notification to support their needs. Also, House Corrections and Institutions and House Judiciary are both aware of this, and they are supportive and essentially told us to chase down the Judiciary bill and see if we could get it added in. But those committees are both supportive of this recommendation.
Thank you. Any questions?
Thank you.
Jay, Haley.
Good morning, everyone. My name is Haley Summer. I'm the Director of Communications for the Department of Corrections. Jen provided a very good overview of the process in which we followed to come to this language, which the Victim Notification Task Force agreed upon. For a little bit more context on DOC's victim services, we provide services to victims and survivors after adjudication and throughout an offender sentence. We're also responsible for information pertaining to release from custody. Our services for victims are overseen by a victim services unit, but it is a responsibility of all staff to provide services to victims. So including our probation and parole officers and caseworkers. Nearly all of the notifications that DOC currently provides through both in-person contact and our automated notification service, which is called VINE, are statutorily obligated. And so when the task force was having discussions around bringing back a menu of options so that victims could opt out of notifications, DOC was concerned that if victims were to opt out of notifications that DOC was statutorily mandated to provide, then we would not be meeting our statutory mandate. So we wanted to ensure that there was language that made it clear that victims could opt out of some of the notifications that were currently outlined in statute, which is what this language achieves. I will note just one thing that I noticed upon receiving it is that on lines 11 and 12, it states a victim may decline any service provided to the department, and just wanted to ensure that the word service also encompassed notification. So bringing that as a kind of point of consideration for the committee and Ledge Council, but that is the only piece of feedback that I wanted to provide, and wanted to reiterate our support over this language and the ability to provide victims with more autonomy over which notifications that they seek to receive and which ones if they don't.
Thank you. It's pretty straightforward. I mean, I think, please correct me if I'm wrong, what I'm understanding is we need this change so that if a victim doesn't want notifications, DOC isn't inadvertently breaking the law.
Yes, that and, there's several notifications that we provide. So a victim would have the ability to choose, they're looking for notifications around parole board hearings, but they're not interested in notifications around someone's release from custody, like just for example.
Okay, seems pretty straightforward. Any questions? Any issues with adding this to the miscellaneous bill? No? Great, thank you. I know we had Black Council up next, so. And you're here on this, you addressed.
Justice language.
Justice language, yeah.
Yes, and this is the land of corrections, to some extent. That means I'm pitching in on the miscellaneous judiciary bill for this. So I think Jen and Haley have already laid out why they're coming to the committee with this proposal. I'll just run through the language. Title 28 does not have a single provision about victims, unlike Title 13. If you go to Title 13, you go to one chapter and get all the victim-related information. Title 28, it's spread out all over the place. So to add, and the provisions related to victim notification are in a number of different places. So to put in one single place, this clarity that victims can opt out of any notification or other services, the best place to do that is in this kind of early section of Title 28 that spells out the powers and responsibilities of the Commissioner of Corrections, basically saying, here's what DOC has the power to do, and here's what DOC has to do. So this would add, it's on page 1, lines 9 through 12. This would add a new responsibility that is essentially describing existing responsibilities in the title, but it would add it to this section or specify it in this section. That the commissioner would have the responsibility to provide notification and other services to victims. Notwithstanding any other provision of law requiring the department to provide notification or other services to victims, a victim may decline any service provided by the department. The suggestion I heard from Haley was for kind of peak clarity on line 11, where it says the victim may decline any service provided by the department. The way the sentence is structured, notification or other services, it's saying that notification is like one of the services we're talking about here, but there's also no reason not to be really clear. And so I think I heard from Haley the suggestion to say on lines 11 through 12, a victim may decline any notification or other service provided by the department. Just kind of looking at that.
I don't think it should.
Senator Rose.
I'm wondering if the way this is worded makes this an opt-in or an opt-out. Like by default, is the victim going to get all of the notifications and have to opt out of what they don't want? Or will they opt in to what they do want?
My understanding, and Jennifer Pullman can hop in and correct me if I'm misstating anything, is that the request from the Victim Notification Task Force group was to provide opt-out as the default. So I think that's the way this was structured. But if Jennifer Pullman, if you'd like to correct anything I said, please do.
No, just happy to provide some clarity. It was intended as an opt-out, especially hearing from survivors that there's so much information that they're getting at different points in time that it felt safer for them to have that as already built in and then to give them the chance to opt out versus the opt-in. Again, with the process being really overwhelming, post-sentence, you get a big stack of papers, victims and survivors do, and it just felt that it was safer to land as an opt-out than an opt-in.
Okay, interesting. And you said there were 2 victims or survivors on that task force. Was there any other conversation with a wider network? And I ask because as a victim of violent crime myself, I would absolutely hate to have to opt out of a flood of notifications. So I just wonder how broad this sort of information gathering was from the sort of network of people you were talking to. And I imagine there wasn't consensus.
Well, we have, the Vermont Center has its own advisory council comprised of victims and survivors of various crimes. I know that the network, and I see that Charlie's in the room, reached out to their member programs as well. And I know that the Vermont State Police advocates reached out to the clients that they have worked with. And those were also included in terms of feedback.
Any other questions? Thank you. Charlie, would you have an amendment on this bill as well? I don't see on the agenda, and it's entirely possible I may have missed something.
I'm happy to hop in there,
Okay,
if that would be helpful.
would 5 minutes, is 5 minutes okay?
5 minutes is great.
And do we have the language? I feel like maybe we could.
I did email the language to you and CC Emery, and I'm happy to forward that email to the top of Emery's inbox if he wants to print it out.
That would be.
I will just take one quick moment to do that.
Emery, is it on the website?
It is.
It is.
It's up on the website? Okay, perfect.
Yeah, would it be easier to just share your screen? That's how long it is.
Yes, I don't have if Emery would be able to send the Zoom link, I'm happy to pull it up. Thank you. Let's hope the fire alarm is gone.
Yeah.
Well, I can get started with a high level overview as I'm getting that Zoom link up. So Charlie Glisserman, I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. And we did send a memo to the chair requesting 2 updates to Vermont Civil Relief from Abuse Order statute. And have those be considered as an addition to the miscellaneous judiciary bill. These were issues that were identified by attorneys working with survivors through the Vermont Network's Pro Bono Legal Clinic. And they were considered by the House Judiciary Committee within H628. We proposed that they be added to the miscellaneous judiciary bill on that end, and unfortunately there just wasn't time to do so. So we wanted to bring this request to your committee. I think this is an example of really good policy, and that practitioners who are working with these laws every day notified us of these 2 tweaks that they would really like to see. So I will bring up that language now as I'm hopping into the Zoom room. So the first is relevant to RFA access when a defendant is under the supervision of the Department of Corrections. So, as you all know, relief from abuse orders, also known as domestic violence protection orders, are a critical legal tool for survivors of domestic violence. They're civil court orders that a survivor can request directly from the court to protect their safety. Now, let me bring up the language that is relevant to this so we can follow along together. How's that for size?
Great.
Perfect. So, to obtain a RFA, a court must find that the defendant has abused the plaintiff and that there is either a danger of future abuse or that the defendant has been convicted of one of a list of serious offenses that are in the statute and is currently incarcerated. Examples of those offenses are domestic assault, murder, and LNL with a child. We propose updating this language by replacing currently incarcerated because of one of those offenses to currently under the supervision of the Department of Corrections. So this proposed amendment would capture those who have committed one of those serious offenses and is incarcerated, as well as those who serve shorter periods of incarceration and then subsequently live in the community on probation or parole. As a result of the agreements, it is common for individuals to serve very short sentences or even no jail time for domestic assault. This revision would ensure that these victims can avail themselves of civil protection orders. Even if a defendant is under DOC supervision, the risk of harm and the survivor's fear can remain very real. But in these situations, it may be difficult for a survivor to meet the threshold of proving danger of future abuse because they are under that supervision. Even though underlying conduct was severe and recent, it is important to make this update to the statute and close this gap to ensure RFAs are accessible to survivors who need them. And as I noted at the top, this is the gap that we see in our legal clinic and one that we would like to close. I would be happy to answer any questions before I move on to the next week.
Don't think we're gonna be able to do questions, but we can definitely find having come in next week as well, just so we can take a deeper dive into it.
Perfect.
So, yeah, if you want to highlight the next section and then.
Yes. Thank you. So through an RFA, survivors can seek a range of conditions of release. They are listed in the statute. They include protective measures, like a stay away or do not contact. And then when appropriate, RFAs can also include some time limited conditions related to divisions of shared property, finances, or dependents. These can look like directing issues around parent contact, child support, or determining who can remain in a formerly cared residence, which we were discussing earlier on in committee this morning. These protections are essential to protect survivors and ensure that they can have the basic resources to lead independent lives when they separate from a former abusive partner. Our legal clinic sees many gaps in how these financial responsibilities are addressed in RFAs. Once the order is filed, payments on shared household bills between a survivor and a perpetrator of harm can often stop. These lead survivors suddenly fully responsible for rent or utilities on their own when they were previously shared, and often survivors are not able to afford to stay in their current living situation. So we propose adding an optional form of relief that a defendant be ordered to continue paying household bills that they were responsible for at the time of the RFA filing. This will permit survivors to make the request for relief, and as with all conditions in an RFA, a judge may or may not grant it at their discretion. But we would support adding this as an option for survivors with low incomes, especially. This abrupt financial burden can be very harmful. It can lead to missed payments, damaged credit, or the loss of utilities or their housing, all at a time when survivors are working to regain their stability. So I really appreciate you making the quick time for me to propose these amendments. I'm happy to come back another time and discuss them more.
Thank you.
Thank you very much.
I think we will have to have more of a discussion. They seem a little more than technical changes. Not that I'm opposed to them, but yeah, but we'll revisit.
Perfect. And I do think that if you look at these changes in the context of the statute, it's, I think, easier to see how, like, there are similar provisions already, and this is just kind of cleaning up and tweaking some language in there. So when I come back, I'm happy to look at the statute with that context.
Thank you.
Thank you.
Thanks for your flexibility.